Hi, this is Pat McDonald, your host for Vote for Vermont, where our tagline is listening beyond the soundbite. Joining me in studio is Larry Crist, who is the Executive Director of the Vermont Parent Representation Center.
Good morning.
Welcome.
Good afternoon.
Welcome back.
Thank you.
And joining us on Zoom is former Commissioner Bill Young, who is still the longest serving, Bill?
As far as I know.
Yeah, the longest serving commissioner for the Department of Social and Rehabilitation Services. And I'm pleased to have both of them on the show. We're going to give you an update of Vermont's child abuse determination system and the Child Protection Registry. Larry and Bill, I'm trying to think how long ago it was that you put out that amazing report.
Second report was 2021.
2020.
Yep.
It seemed like it was just yesterday, honest to goodness.
It does.
Yeah, these two gentlemen worked so hard and put out a report that kind of got everyone's attention in Vermont about what's happening with the social and rehabilitation services and the determination system that we have here for our children. And I'm going to ask them to explain it to you, and then we're going to talk about what's happened since then, and hopefully it's pretty much fixed at this point. People have been paying attention. There's still work to be done, but we're on a good trajectory, I would think.
Well, half the problem is fixed.
There you go.
Or being fixed. There's still another half to go.
Oh, can you start us off with telling us what you all discovered when, because you both worked in the agency.
Yes, we did. And in fact, Bill is the person who recruited me to come to Vermont. And who knew that 40 years later we would still be working on the same issues. But the report you're referring to, Pat, there were two reports.
Right.
And the first came out in 2018, of which Bill and Trina Beck and I authored that report. And it identified a holistic picture, a comprehensive picture of our child protection system and what we found to be deficits, areas that needed improvement. And the report touched on a variety of issues. I think there were some 60 findings and maybe 80 recommendations in that report. It came out in 2018. It was called Bending the Curve to Improve Our Child Protection System. Within that report, we highlighted two key issues. There were more, but two were highlighted. And the first was our substantiation system in Vermont and the use of the Child Protection Registry. And as you know from earlier discussions, what a substantiation is where the Department for Children and Families gets a report of suspected abuse. They review the report. If they decide that it's something they should investigate, they conduct an investigation. If at the end of the investigation they believe that there is sufficient evidence to substantiate someone,
Right.
in other words, to label that person as a child abuser, then there's a whole process that kicks in, and the individual has a right to an administrative review, and then if they are not successful at that level, they move on to the Human Services Board, which is a more formal administrative review. Shortly put, the name of the person, if they are substantiated, goes on the Child Protection Registry, of which there are about 25,000 names on the registry today, at least the last number that I heard. If you are on the registry, you're precluded for about a third of all the jobs in the state of Vermont.
Because people over time have come to rely on that to see what kind of person they're interviewing and possibly hiring.
And it's not just have come to rely on it. In many situations, they're required to check it, to check the registry. So if you apply for, say, you want to be a school bus driver, or you want to work for a school or a child care setting, they have to check the registry. And it has really sort of been expanded to include any situation, a hospital, a school, a child care program, It can even be, in some instances, a construction company that does a lot of work in a school while students are there.
Oh, wow.
So you get the sense of,
Yeah.
of just how broad this is and why it's so serious. And our concern was that the system had never really been tested. How accurate was it in determining whether an abused, a person charged with abuse really, whether there was sufficient evidence? The other major issue was the representation for parents who go into family court because of some child protection issue. The majority, vast majority of families do not have the resources to hire a
Right.
private attorney.
Just basic money problems, right?
Yeah, exactly. And so they are provided with a public defender, if you will. It might be someone out of the Defender General's office, or more often than not, it is a private attorney who is contracted with the Defender General's office. We identified in our first report that there was that there was concern about the quality control with regard to how active were these attorneys, and how frequently did they steer their clients to simply admit to guilt, simply to move the case along. And also to understand, for attorneys who decided that they really were going to defend their client, how long that took, the resources that were involved, and what the attorneys were compensated for. The first report dealt with broad issues.
Right.
Our second report dealt specifically, as we talked about on this show
Right.
about a year and a half ago, with the substantiation process. And we've authored another report based on 3.5 years of experience of testing the system. And what we found is, if a parent was accused of abuse or neglect, and they were provided with a competent representative in their hearing process, it would turn out that there wasn't sufficient evidence to actually substantiate them.
But what was happening was staff was just moving them along, or?
Well, it's a combination of things. You're not provided with an attorney in that process.
Right.
So most people initially, most people would wind up defending themselves, which is very difficult to do.
Sure, right.
And at the first round, there is something called the Commissioner's Registry Review Unit, which is an informal process. However, if you're not successful at that level, it then goes to the Human Services Board if you appeal it. That's really a process where the Vermont Rules of Evidence come into play. And it's no longer now the parent dealing with a representative from DCF, it's the parent facing the Attorney General's office. A completely different process.
Right, different skill set too, I'm sure, just
It's
presenting.
totally
How would
different
they
skill
even know
set.
where to start?
There are outlines
Yeah?
about how to
Oh.
do it, but the process is sort of like asking us if we want to do brain surgery
Yeah, right.
on ourselves.
Exactly.
Well, the
Piece
answer
of
is
cake.
right, piece of cake. I can do that.
Yeah.
I'll read some stuff. I'll go online. I'll look at YouTube. That's not the way it works.
Right, for sure.
And what we found was that most people who had been substantiated and their cases went to the Human Services Board lost.
I'm going to just bring
yeah.
Bill in here for a minute. Bill, what puzzles me, and I'm trying to, you've been in the trenches, you both have been in the trenches for years. How did you see that how did you think that maybe there was a problem? Because, we've always done it this way, and that's the way we've done it, and that's sort of state government, isn't it? I mean, so
Well,
how
I
do you
think in
know?
terms of the problems that Larry's describing, they were certainly present, I think, while I was there to some degree.
Right,
But it was a very different agency. It was a much smaller agency. It was possible for Larry, myself, the deputy commissioners, other managers, to pay closer attention. And that's not to say that we caught everything, because I think because of the problems Larry's been describing, you can't. But it was possible to pay attention, and if somebody called and complained, to do something about it. And that's not to say that I think there are plenty of these issues that we're going to describe were still there. And,
Right.
when I was there, certainly the issues with the legal system, I didn't hear much about. I didn't run it. And you pay attention to the things you're responsible for
Sure.
directly.
Right.
So that part of the system, I think there were probably a lot of the same issues that Larry, that we'll be talking about in a few minutes.
Right.
I do think with some of the others, it was possible to pay close attention because it was a much smaller agency.
Yep.
And if you wanted to pay attention, you could. But I think what's happened with the legislation Act 154 that just passed,
Yep.
and the department I don't know that they've filed it yet, Larry, but there's a report due to the legislature on how well they're implementing that law, which of course is where the rubber meets the road in terms of how well that's going. But people think of the child protection system as DCF, or my former SRS. And that's the child protection system. But that's half of the child protection system. The other half is what Larry's been describing, is the system of the legal system, which involves, when you go to only, except for severe emergencies, DCF can't bring a case before a judge. The state's attorney has to agree with it, and the state's attorney has to bring it to court. Every parent has an attorney. Children have an attorney and a guardian ad litem. They're all in court. The social worker or a DCF representative, usually a social worker, is in court. The way the system is supposed to work, they all present their independent decisions, and the judge makes their independent decision.
Right.
The problem is the system is terribly flawed, and as a result, real injustice is being done both to children and parents. And it's not just substantiations being made that shouldn't be, or kids coming into custody that shouldn't, or not going home when they should. There's also cases of kids who should have come into custody and weren't. We had a horrible case quite a few years ago where a child was terribly abused, taken into custody, and not terribly long time went by before they were sent back home again, and a real disaster took place. And a friend of mine, the late Kate Piper, a wonderful attorney in St. Johnsbury, she's died now, was interested. She was retired, and she started looking into that case to see what happened. And she called the person who had represented the child and said, I see that you didn't object to the child going home, and I was just curious why. And the person said to her, I wasn't the attorney initially. And when I was assigned it, I just, when it came up that the child was going to be sent home, or there was a motion to send her home, I didn't know what had been done to her to begin with. What had been done to her to begin with was horrible abuse. And the person representing the child didn't have the training to know, as Kate said to me, because she'd done a lot of these cases, the first thing you do when you're assigned the case is you look at why did the child come into custody.
Right.
Now there's an example. That's just one example, but they go both ways. And if mistakes are made and they're not caught, and the system is designed, to present a whole lot of different information, and judge independently makes decisions. But if folks don't have particularly in the legal system, if the attorneys for the children and the parents don't have the training, and they're not paid appropriately, and they don't have the caseloads that are low enough so they can do a good job, then you have real disasters happening all the way around. And it's either way, kids are hurt and parents are hurt. And there's no reason why we can't put in place a system. Many other jurisdictions have done it. There's federal money available to create, as I think Larry mentioned, interdisciplinary teams with attorneys, social workers, and sometimes a peer, to really focus on every case in many cases, you're talking with folks that are poor, have a whole host of other problems, and if they can get those resolved, chances are much better that they'll be able to, work things out with their kids in safety. And everybody benefits from this kind of a system. There's money available for it, but there just doesn't seem to be there hasn't been a willingness within the legal system to address these issues. Frankly, the Defender General's office typically says in testimony to the legislature, everything's great.
Yeah.
People are well trained, they're well paid, they have appropriate caseloads. It's just not true.
Right.
And it really, I've talked to attorneys who it's not that there aren't good people in the system, but I've talked to some folks who are doing a great job, and they've said, I got myself trained. Somebody else said, well, I was in pretty good shape, and then I came to the office and they dumped 20 more cases on me, all at the same time.
Wow.
This has to be a system that makes sense for everybody. DCF can do a really good job, but if that legal system is not working, we're going to continue to have serious problems.
I think even
And there's just no reason why we can't fix it.
there's an issue from years ago when I was involved with this stuff at the Guardian ad litem's. Some of these people have way too many. Like somebody told me they had 50 cases. I can't even imagine how you can track 50 young people, 50 kids, and be responsible for making sure that their rights are honored. I mean, that's ridiculous.
And I think, Pat, that's a great lead-in to sort of the overall issues that Bill
Right.
has outlined, and what the former piece of legislation that passed,
Right.
Act 154, that cleaned up the substantiation process. What I mean by cleaned up is it made the law make much more sense. DCF has to produce more evidence now than they did before. The time frames for making your appeals are more realistic. The notification of people that you've been substantiated
Right.
now is no longer done by a first-class letter sent to your last known address. And if you didn't respond within 14 days, you lost your appeal rights entirely. Those things have been addressed. And so the process, I think, and I think DCF agrees as well, because we went into the legislature arm in arm with this proposal. It has made it much fairer, and at the same time, it has helped DCF sharpen its investigative abilities. But what Bill was just describing is what happens on the other side of this spectrum when families enter family court. And I'll give you an example of the process. You may remember a judge here in Vermont by the name of Ben Joseph.
Oh, for sure.
And Ben Joseph used to tell a story about after he retired, he agreed to come in on a part-time basis in family court and assist with cases. And because he was retired, he had some time. And one day he went into the court a day ahead of time and read the files of the cases that he would be hearing the next day.
Right.
The next day, on the very first case, he asked for a show of hands in the court. Now remember, this is not an open court session. Family court is highly confidential. There are only certain people allowed in that room. And in fact, it's so confidential that there's a $2,000 fine if you take information from family court and make it public.
Wow, that's great.
Even to the people who are involved in the process, without a court order to do that. So Judge Joseph said, how many people in this courtroom, not the parents, have been with this case since the beginning? No one raised their hand, because there had been so much turnover at DCF, at the state's attorney's office, with regard to the defense attorneys. Not a single person had done that.
No continuity at all. Just
So Judge Ben then asked DCF, can you tell me where this child is placed today? The worker was a new worker who had to reference their notes and gave the name of where the child had been placed. Judge Ben said, correct me if I'm wrong, but isn't that the home where this child was abused initially? And the answer was yes.
Oh, my word.
So Ben Joseph said, we are stopping this proceeding.
Yep.
No one will leave this courthouse until we have relocated that child to a safe
He's so great.
home.
Yeah.
That was, and he said the only reason he could do that was because he went in the day before and read the entire file.
Yeah.
What that describes, though, is that a judge who sits day in and day out doesn't have the time, in most cases, to read the files. So they are completely reliant upon what the state's attorney presents to the judge, and the state's attorney is completely reliant upon what information DCF provides the state's attorney. The defense attorney doesn't have access to those same resources. Wow. And in the very beginning of cases, where there are the emergency care hearings or the temporary care hearings, they don't have really any information. They may have only met their client minutes before they walk into court.
Right.
What we have found in our work, and I'll tell you two quick stories that outline this system itself. The first is a mother who had her child removed based on the child's allegation alone. No supporting evidence. That was 3 years ago. She has not seen the child since. Initially, for the first year and a half, she had an attorney who really worked on her case and thought that the attorney had brought the case to closure because of a stipulated agreement. However, the stipulated agreement was altered in the process, so the mother appears to have agreed to something that she didn't agree to because the language was rearranged. That attorney left the case because she was closing her practice out. Another attorney was assigned. That attorney worked with this case for almost 1 year and 4 months. That attorney did absolutely nothing for 1 year and 4 months. The mother finally came to VPRC and said, I don't know what to do. My attorney doesn't return my calls. We've never talked about this case. I've never met with the attorney other than just a few minutes before court. So we worked with the mother to try to get the attorney to do their job. That didn't work. We worked with the mother to be able to ask for a new attorney. She did. The court awarded allowed the second attorney to leave and appointed a third attorney. The third attorney got the case file and found that there was not a single note in the files that was new since the second attorney had been hired.
Wow.
Nothing in the files.
Wow.
Yet they were moving toward a termination of parental rights trial that was coming up. So now we have a third attorney who is faced with a TPR trial, termination of parental rights, who has no information except information that's years old now and is expected to pull all of this together. Fortunately, this attorney has on their staff a social worker and an investigator. And they work collaboratively, the three of them, which just so happens to be the national model. But it is not a model that Vermont has employed. And what we have tried to do with a bill last year in the legislature and a bill coming up is to say this interdisciplinary legal representation system is being done in at least 16 jurisdictions around the country. They all are producing outstanding results, which means fewer families come into family court, fewer children are removed, the children who are removed are returned sooner, and the children who should be removed and are never going to be able to go back to their families are adopted sooner. It's a win-win.
Right.
Now, here's what makes it a win-win-win. The federal government, since 2018, has offered every state that adopts this kind of system and tracks the outcomes a dollar-for-dollar match.
Wow.
Currently, the Vermont defender system for family court is entirely general fund. It's entirely Vermont taxpayers. The federal government is sitting on the sideline waiting for Vermont to get its act together
Right.
to be able to match the money, which would require the state, instead of it being this one attorney who has put together this team,
Right.
this is what every attorney is supposed to be part of. And it includes extensive training. It also includes supervision. I think we all know that attorneys, doctors, public servants, everyone tries to do the best job they
Yes,
can.
that's true.
But if none of us are supervised and no one sees what we do because these cases are confidential, we know what happens. Human nature sets
Right,
in.
right.
And then, if you are not paying people enough to spend the time, the outcome gets worse. And so what we find is that the typical process is parents who rely on the defender system don't meet with their attorneys. The attorneys who represent the kids frequently have never met the kids. As you pointed out, the guardian ad litems
Right.
in this state, it is a volunteer position. It's a huge amount of work.
Right.
And people often carry multiple cases. Whereas in other states, Massachusetts as an example, they use the CASA system, which is a specialized, we think of it as a guardian ad litem, but it's called CASA for a reason. They are allowed one case at a time. In exceptional circumstances with very experienced people, 2 cases.
Wow, not here.
Not here.
And I think just to jump in, Larry and I try to be careful about promising things with the budget that we don't necessarily
Right.
control.
Right.
I mean, this is clearly something that as a state we're really crazy if we don't implement this kind of system, because there's so many examples of it being done and the results that you get. But it is certainly true that there are states, Washington was one example, that implemented this system and saw a significant reduction in state funds. Now, this is a huge state. The amount of money that they found that they were, it was a large reduction in they counted child days in custody. And it was in the millions of dollars that were saved. And, we try not to promise that because, different systems are different. But the legislature, they were also, when they saw that, the legislature, their Supreme Court were all deeply involved with this. They said, well, wait a minute, we didn't do this to save money. We did it to provide better outcomes for children and families. So we want to know, as a result of less child days in custody, are more children being abused? And they had all that information, and the legislature looked at it. And the courts looked at it, the Supreme Court looked at it, and they said, aha, we saved all that money, and there's not one jot of difference in the percentage of re-abuse, when kids are going home. So, there were many more kids going home, no change, no increase in abuse as a result of their going home. And it just, but that's the kind of attention they were able to pay because they were paying attention. And so we don't promise that the state's going to save millions, but in all these jurisdictions where we see this going on, it appears that many of these cases, there are less kids coming into custody. But as Larry said, there are also situations where kids should come into custody, and they do, and they're protected. And things, if it's clear that they're not going to be able to go home, things move along quicker towards termination of parental rights and adoption.
Wow.
But there's just no reason why we can't do this. And there's different examples. In some states, there's, you may have one agency, for example, in Vermont, it might be the Defender General's office, has attorneys that represent children, and it might be a different agency that that has funding to represent parents. I mean, there's not a exact way to do it, but the systems that work all have good training, reasonable caseloads, reasonable pay,
Right.
and good oversight. And if you don't
That
have that
doesn't sound too
oversight, whether it's
complicated.
the Child Protection Agency or the courts,
Yep.
if you don't have good oversight, things aren't going to work the way you want them to work.
Right.
What is your feeling about our legislature? Are they getting that something has to change here? Especially if you're looking at the feds, a dollar for dollar match. I'm surprised none of our legislators have jumped on that, or maybe they have.
Well, last legislative session, a bill was presented. It passed through the House Judiciary Committee unanimously.
Great.
And then it passed through the House unanimously. In fact, to create a study group to identify all of the things we're talking about now and include a lot of stakeholders in the process. Unfortunately, when the bill went to the Senate had run out of time.
Oh, so
It
it's
was
still
toward
sitting
the end
there.
of the session. There was some miscommunication between the House and the Senate. But interestingly enough, in the House Judiciary Committee, one of the questions that legislators asked me repeatedly is, Larry, if this is being demonstrated around the country, you know what this should look like. Why do we need to create a study group? Why don't you just bring us a bill that says, we will do thus and such? And I did my best to explain to the legislators. It doesn't mean I was successful. I just did my best. As Bill will know, they're not the same thing with me. But my response was, we want to make sure that everyone who's involved in this process has some ownership in it and some say, and we want to include all the voices that are
Right.
here. Well, it turned out that virtually every organization that was connected was in favor of it, with one exception, and that was the Defender General's office. Because as the Defender General's office stated to the legislature, they feel they're already doing this. Our experience, which is considerable and has gone on for years, is that in theory, we would like to do this. In some cases, we do it, but the system isn't set up to do this. It just isn't.
Right.
And so we get the outcomes that we get. So this leads me to another story that clearly identifies how this could work. I was contacted this past year by a social worker / therapist who called and said that she had been engaged in therapy with a gentleman who was involved in family court. The issue was domestic violence tied to alcohol abuse, and that the case was moving toward termination of parental rights. But her feeling was that this didn't make any sense because this person had been coming to her for counseling and was doing well in counseling. That the person's attorney really wasn't actively presenting information to the court. And she didn't know what to do. And I said, I'll tell you what we will do. We're going to create an interdisciplinary team. Your first job is to get the attorney to agree to do it.
There you go.
Your second job is we have to identify another social worker who will actually be the case manager for this individual. You're his therapist. You can't be the case manager. She found another worker within a matter of days.
Grief.
This individual, the parent in question, had done and was doing everything that DCF had required of them, except a couple of key training things. And the reason they hadn't done them is because he's not an English speaker. And no one in the system could find an interpreter. So therefore, he couldn't participate in these courses. He wanted to, but he couldn't because he couldn't follow what was going on. So the case plan that was put together was this social worker, who was now going to be the case manager, was going to find an interpreter. They had been looking, they being DCF in the broader system, had been looking for a year.
Wow.
She found one within 24 hours.
Oh, great.
Got the gentleman signed up for the courses, and he began the courses.
Great.
All of this information was brought to the attorney, who said, look, I'm burnt out. I cannot really do much for this man. I don't see how we can win this case. The original therapist said, if we bring you the case, will you present it? To the lawyer's credit, the lawyer said yes.
Good for him.
All of this work was done within a 2-month period. Now, this case had been going on for several years in family court. You can imagine the money that's being spent on this. Within 2 months, the whole case plan was put together showing he had done everything. This was all of the successes. There was nothing left for him to do. The day before the TPR trial began, the attorney brought this information to the Attorney General's office, which is who handles termination of parental rights, and the Attorney General's office withdrew the termination from parental rights petition. That is how an interdisciplinary legal team is supposed to work and can work, even on a completely voluntary system. It just needs to be orchestrated. Imagine what you can do if you can actually pay people to do this.
That's great.
So the reality is there is no reason, there really is no reason at this point that Vermont shouldn't adopt this model. And there is a bill that will be shortly introduced which doesn't call for a study group anymore. It says this is what we should do. We're going to do it. And we don't have a bill number yet, but I anticipate one very shortly.
And what's the committee that would be assigned to?
The jurisdiction is likely to fall to House Judiciary, House Human Services, and then go to the Senate.
The Senate, right.
And the reality is there are now attorneys who are willing to come forward and testify about the reality of the workplace as they have seen it and what they have done to try to adopt this model and make it work.
Now, we've mentioned before Act 154. Now that got passed in 2024.
Yes.
What's happening with that? Because there's a lot of recommendations in there. There's a lot of real solid. Do this.
Yes. As Bill indicated a few moments ago, DCF, the Department for Children and Families, are to provide the legislature with a report on exactly what the question you just posed. They have been working diligently since the passage in June of 2024 of Act 154. They have formed a number of committees involving DCF workers, people like myself from the outside. There's been a lot of hard work put in. Commissioner Chris Winters did a phenomenal job working to usher the bill through and then to make sure that it was being implemented. So DCF has restructured its training. It has implemented all of the must-do reforms, the change in time limits, the burden of proof, not the burden of proof, but the standard of proof, moving from reasonable person to a preponderance of the evidence, which means you have to have enough evidence so that at least it was more likely than not. It was 51% of the evidence or greater. All of that has gone along really well. I have to credit DCF and the individuals in DCF who have worked tirelessly. There were other pieces which you need to look at, and one of those things is, should everybody who is substantiated go on the registry? Because one of the things that Vermont has lost sight of is the registry isn't a punishment, because it doesn't really punish people for having done something. It's designed to protect children from future abuse.
Right.
Well, if you're a parent and it's bad parenting or not great parenting, and it just crosses that line that only a parent is going to encourage, should that person be on a registry that says that they can't drive a school bus or they can't go on field trips from school? Because the event isn't going to happen. They've gone through a process of showing that they understand what they did needs to be changed, and they've taken the steps to change it. And this is the best example, something that happens that can only happen to a young child. The person's been on the registry for 20 years now. That child is 20-something years old.
Really?
And it could only happen at home with the kinds of stresses that a new or young parent faces.
Right.
Why? It sounds easy. We won't put everybody on. Now the hard part is figuring out who goes
Right.
on and who doesn't.
Yep.
And I can say from my own experience working with DCF, it is a hard subject to work through.
I would think so.
But the department is making real efforts to do so. The other really critical piece from my perspective, that the law has DCF to come back and explain what they need to do to record key interviews, because there was no recording of interviews. So a DCF report may say, mother admitted that she did X, Y, and Z. When you talk with mother says, I didn't say that. I never said that. And there might be one or two other people who were there. Or one of the best cases, a DCF report says that the DCF worker interviewed X, Y, and Z children. Then you find out, never interviewed them.
Wow.
But there's no recording. And in these situations, usually the system leans towards supporting the agency as opposed to the individual. Now, what DCF has to present to the legislature is how could they go about taking recordings of interviews and maintaining them so that if it goes to hearing or trial at some point, there is evidence, and it works in both favors.
Right.
Favor of the parents who say, I didn't do it, and check, you're going to find it's not on the recording. Or the department that says, this is what they told us, and here's the recording.
Wow.
It makes it much clearer for
For
everybody.
sure. And
that-
I
yeah.
would think, seemed to me when we talked last time we did a show, I would think as an employee, I would rather have those kind of guidelines spelled out. You have to do X, Y, Z,
Yep.
because it makes your job much easier, because there's a lot of ambiguity here about what is and isn't serious. I mean, that's a lot of
Absolutely.
guessing,
And-
not guessing, but, well, decision-making that
And
hard
because
to do.
people like Bill and I and Trina Beck, who has co-authored the reports we did, because we all worked in the system, we
Right.
came here to Vermont. Some of them were born here.
Yeah, right.
Others of us came to make the systems work
Right.
better, not with a particular agenda, except to make the system work better. And that's what we've tried to do in all of these processes.
Well, and when I was doing my research, I found quite a bit of support from people like Emerson Lynn. He wrote an article about this, so you've gotten the word out. I think that that there's an issue here. I was surprised after we did the show that there were people who were sort of pushing back on it that I knew, and I think we had talked a little bit about. I just surprised that some people weren't like, "Wow, let's fix this."
Yes, and for good reason, because we all know that systems can either evolve or
Yeah.
they can become a pendulum. So we take too many children, now we don't take enough children. Now we're going to take too many children,
Right.
and we go
You're
back
right,
and forth.
right.
As opposed to trying to find a way, as Bill identified, to make sure that the system operates the way it's intended to work, so that children are safe, but families are also protected.
Right, because once you're on that list, your future is slightly dimmer.
It is-
Because
it
you
is-
don't get jobs, it probably
Right.
won't get much
And the
response.
majority of those jobs are usually entry-level jobs for women who are single parents. And so what we have is this double whammy, if you would,
Yep.
where you lose your child for a while, then you can get your child back, but you're on this list, so you really can't get the kind of employment that
Right.
would typically be open to you.
Wow.
And therefore better your life and your child's life. And DCF understands that. I
Yeah.
think they have evolved along with all the rest of us in this process, because it is a constantly evolving world that we live in. And at the same time, we never want to lose sight of the fact that the child protection system is there for a reason. It's to protect children, but not at the expense of sacrificing families.
Right. Now, you said before, and Bill, maybe you can comment, that there were 25,000 names
There are approximately 25,000.
That seems to me to be a lot. Is that
Well, remember.
less than what we used to have as they become more aware of issues?
Well, here's what happened. Primarily, for most of the time Bill was commissioner,
Yeah,
the registry was not open to employers or anyone else.
right.
It was solely used by SRS for licensing purposes and to tell the federal government, here's our range of child abuse in
Yeah.
Vermont, so they could they could compare it to other states. Then the legislature, in its wisdom, because of the deaths of two children specifically, actually it predated that. Bill can clarify it. But they opened the registry for employment purposes.
Wow.
That changed the name of the
Yep,
game.
right, I would think.
And Bill
Bill,
can
can you-
explain
Pat,
that.
it was really, they say bad cases make bad law.
Yes, right.
You had a few cases where, for example, somebody was in the registry for a child sexual offense and wound up working for a school. And of course, the information wasn't public, but they were on the registry for that, and they molested a child. One case, and you don't want that kind of thing to happen. But all of a sudden, you have this tremendous movement to open the registry and to open it more and more. And it was very difficult to go in and say, well, I don't think we should open the registry. And people, well, what about this case? Do you want a sex offender in the school?
Yeah.
Well, no, I don't.
Right,
But there were a handful of those cases, and they really drove that whole system. And you really can't argue it. But by the same token, do we really need tens of thousands of people in the abuse neglect registry when their kids are, approaching middle age?
yeah, right.
Now,
That's just what you said,
and particularly
30-year-old.
if they were substantiated for
Yeah.
something that was, on a scale of abuse and neglect. Really, it happened, but very minor. It was taken care of. You really didn't feel that they were a tremendous risk, even at the time when you were closing their case.
Right.
Yet they were still prevented from getting all these different jobs in Vermont.
If they're on the registry now, are they required to go through any specialized training, like not to injure your children?
They are not required to do that, but the only way to get off of the registry is to petition the Department for Children and Families for expungement. And there's a statute which outlines the rationale and the things that the commissioner will review.
Right.
But it's a completely subjective process. One commissioner could decide that this and this are okay. The next commissioner could say,
Right.
no, those aren't okay. You have to have done this and this.
Right.
One of the things that the statute, that Act 154 brings into question is when someone does apply for expungement, it's like the hearing process all over again. But that what we discovered was people were being denied, but not being told what they had to do.
Oh, wonderful.
And now it's required that they are told if they're not successful with the expungement, the department has to explain to them why and what it is they need to do.
Great.
And it's, as I said, it's very complicated. It's really challenging. So the earlier we start in the process with investigations, both for abuse and neglect substantiations and investigations for family court, because they're often both about the same thing, the better we are collectively at getting the right information present at the right time, the fewer people will wind up in the pipeline.
Right.
Because the goal is to take the finite resources that we have for child protection and use those for the most serious cases. The system simply can't do it for everybody.
Right.
And to some degree, DCF screens out a lot of cases and they get complaints about that. They often screen in cases that we believe they shouldn't have screened in. but we can only fix parts of the system.
Right. Well,
The
that's
idea
huge.
is to have better trained people with better laws and rules, and then monitor that process. And a lot of that goes back to the family court system. If a judge can get good information from a defense attorney, good information from DCF, then the judge can make good
Good
decisions.
decisions, right?
As opposed to getting only one side of the story that no one can validate, where you come out with decisions where you just scratch your head
right.
and say, how in the world could a judge do that? Then you go back and look at the information they were given.
Yep.
So,
That's right. So we have 7 minutes left. I want to talk about what needs to happen now. What's going to keep you busy well, they're already in session. Today was their first day, or yesterday. I think Phil, the governor, gave his speech
yes.
yesterday.
Yep.
So.
This was the first week.
Yeah, first week.
But it's mostly.
So what are you hoping to have happen this year?
What we are hoping to accomplish this legislative session is to provide all of the education, as much education as we can and information to the legislature to aid them in making a wise decision about what reforms to put in place. And at the same time, to stress, this state, Vermont, like many states, are facing cuts in federal funds for food,
Right.
federal funds for housing, federal funds for transportation, federal funds for emergency response. All of those are being reduced. Here's an opportunity for us to improve a system and get the federal government to finally, after all these years, share in the cost.
Great.
And that allows us to implement this interdisciplinary system, pay people adequately, and expect their best.
There's a concept.
Yeah,
Isn't
it is. It's radical. I realize it's a radical
I know,
concept.
exactly. What are you thinking? That's great. Bill, how are you going to be involved this year with Up the Hill?
Well, I'm certainly, of course, I'm at a disadvantage because I'm down in North Carolina.
Right, exactly. In the warmth.
But I will certainly be, glad to testify, as I've done before,
Right.
with committees that are considering this. There's a lot going on in the legislature this year and a lot of challenges.
Speaking of education.
But, there's really no good reason not to do this.
Yeah.
It shouldn't take a lot of time to make that decision, I don't think.
Yeah. And who is the new secretary that took Chris Winter's place? Who is the
There is an interim commissioner at this point. To the best of my knowledge, they have not appointed, the
really?
governor has not appointed
I hope they do.
a permanent. Yes, that would be very helpful.
Yeah.
The interim is a person who I have not yet met, but who comes with a solid background.
He's laughing.
Pat, my name isn't in the running.
It should be. You're the longest running DCF commissioner. You're famous worldwide here. Anyway, you and your buddy Tom.
I'll be 80 in March. My days of doing
Don't
that
talk to
kind
me.
of
I
work are
beat you
so
by
long
2
gone.
years.
Yeah.
I'm 82, so there's no we're here. That's all I care about.
It's not
That's
often
right.
I'm
Yeah.
youngest in the room.
Yeah, exactly.
And
It's
that
really
certainly
scary.
isn't the case in the
Yeah.
legislature.
Listen, I wanted to share something with you both. If you remember our last show that you were talking about the broken system, broken promises, we won an award for that show. And
Really?
I know I emailed you, but you never saw the picture of the
That's
plaque
great.
itself. It's from it's a national award, and it's called the Hometown Media Award winner. It's Vote for Vermont, which is the overarching sponsor here. Report on Broken Systems, Broken Promises, and we won in 2023. Isn't that cool?
Very good. Congratulations.
Well, no, it's you
Yes.
guys. It was the storyline in you two. I take no credit for this. That was great. So maybe this one will do it too, a follow-up.
It's
So-
important to get the word out so people understand
For sure.
what the issues are.
Are you going to go do any, like, to the Rotaries and those sort of groups, presentations?
The reality at this point is the legislature's aware of this issue. They understand that it needs to change.
Right.
It's time for the legislature.
Okay.
It really is.
Step up.
And then time for the governor to follow suit.
Right.
Who, signed Act 154.
Right.
And I don't question that if the legislature passes the legal representation reform bill, once it is introduced in committee, that the governor will sign that as well, because it is in the best interest of Vermont from a social perspective, from a legal perspective,
Right.
and from a financial
And this
perspective.
really is for our children.
Absolutely.
For sure.
It is. And they're just, at this juncture, there's no reason not to.
Right. And 25,000, is that compared to other states, is that,
It's very hard to compare.
is it?
It is. We've tried to do comparisons, and states have changed their rules over time. So we tried to compare to New Hampshire. We couldn't, because what we found was that New Hampshire at one point had a law in place that I think if it was 7 years, after 7 years, you automatically came off.
Oh,
Whereas in
We don't have
Vermont,
that.
you're on it
Yeah.
until expungement occurs,
Right.
if it occurs. So you can't compare them. And
Interesting.
we found other states would only put certain people on the registry, not put other people on the registry.
but there must be some states out there that have got the magic formula that we could steal, cross their name out and put Vermont.
To DCF's credit, it has looked at a number of systems and then tried to pull the best pieces
Right.
from those systems and said, will this work? And I can tell you, it's a fascinating discussion when you get
Right.
people from all different backgrounds looking at the same issue and trying to come to a consensus
I would think
of
so.
what should be
I
there.
would think so. Well, gentlemen, any final words as we close out? I wish you all the luck this year. This is going to be interesting to watch. I will watch it myself just personally, but have
Well,
you back on.
I just want to thank you for giving us the opportunity to
No
come
problem.
on and explain this to
We,
people.
we really appreciate it, Pat. Thank you for your interest. It makes a difference, I think.
Well, it's just so important. I don't understand it, especially once you get the implications of jobs and grants and all kinds of things that you can't get if you're on that registry. And if you don't belong there, get them off. I mean, that's really devastating to the families.
Yes, and one of the things that I will add, that we didn't add, is that in the proposed bill, the attorneys who are handling a case in family court for the parents, if the parents have a substantiation also, the attorneys are going to represent them now in the substantiation hearings. DCF's approach to this is they think that but that by itself will significantly reduce the number of people who go on the registry.
That's great. Well, you've got somebody that knows the people involved and
Absolutely.
and can support
Yep.
or
And
not.
understands the law and
Yeah.
has resources to do what a small organization like VPRC has tried to do for people.
Very nice.
But the resources, when I help 10 families, that's 10 out of maybe 500 families. It was enough to show us the system didn't work, but it's not enough to fundamentally change how the
Well,
system
I
operates.
hope they're paying attention and put this right up on the priority list because it needs to happen. I totally am supportive and I wish you both a lot of luck. And then meanwhile, we're going to close out the show. I thank you for tuning in. I hope you found this very interesting. Give me a holler if you want to find more sources of information. I will be glad to provide it to you. In the meantime, it's Pat McDonald, your host for Vote for Vermont. We'll see you next week.